Every day, news reveals the commission of multiple genocidal behaviors or warning signs different from those defined in the Convention on the Prevention and Punishment of the Crime of Genocide of 1948 and in the Rome Statute of 1998. The classification of conduct in the international spheres enables and legitimates the complementary competence of the International Criminal Court, but its intervention is limited to the restricted classification of the crime regarding the groups of human victim potentials. In the exercise of right to veto, a single country of the permanent members of the UN Security Council can prevent the implementation of measures taken to block or counteract the generated factors or genocidal conducts by also attempting against their autonomy and independence. All these situations make the adoption of the measures proposed by the Global Embassy of Activists for Peace through the program Justice for Peace necessary. It's a program of social intervention with a global range and whose purpose at the international level consists in the elaboration and implementation of strategies aimed at updating and amending the Convention on the Prevention and Punishment of the Crime of Genocide, the Rome Statute, and the regulations of the United Nations with the objective of broadening the scope of protection to other human groups excluded from the classification.
We need to democratize memory, to free memory from political influence.
International regulations are made to protect us, not to protect the governments.
Democratize the UN by expanding the numbers of countries that are permanent members of the Security Council, eliminating, democratizing, or rationalizing the right to veto when trying to prevent, investigate, or judge the crime of genocide. Strengthen the International Criminal Court and its General Prosecutor's Office. At the national level, the program seeks to re-examine the national legislations in order to update, modify, or present a bill to criminalize genocide in those countries where it is not yet typified, including politicide and ethnocide, as well as strengthening the justice administration, define its scope, and promote respect of human dignity, the presumption of innocence, and human rights, as well as the recognition and respect of the victim's right to truth, justice, reparation, and the guarantee of no repetition.
If human rights enforcement mechanisms are to regulate the potentially hostile acts of states,
the judiciary should be kept away from the influence of the other organs of the state.
In this sense, it develops the following projects: new proposals for the prevention and punishment of the crime of genocide, democratization of the UN, classification of genocide, strengthening of the International Criminal Court, promotion and protection of human rights, program of dissemination and research of genocide in the world. In order to generate constructive critical thinking on criminal policy regarding genocide as a capital crime, it is necessary to socialize and enrich these proposals through academic encounters such as the national and international judicial forums and the Justice and Democracy session of the Peace Integration Summit, CUMIPAS, whose objective is to form an international network that promotes these proposals at every level.